Assalamualaikum. My name is Zuraida. I am a student from class NBF 5A with the student ID 2022688036. I am excited to present the topic of Salient Shariah issues in the contemporary application of HIBAH. To begin, let me explain what is HIBAH. HIBAH is a gift given without any expectation of return or compensation. Offer and acceptance. The offer and acceptance must be engaged in clearly, without any margin for the mistake. The donor must make the gift and the person receiving it must accept it honestly. Donor's eligibility. The donor must be of a legal age and be a good mental health. The asset being given must be fully owned and controlled by the giver. Recipient eligibility. The item being given must be able to be accepted by the receiver, or a guardian may accept it on behalf of a disabled or children. Ownership of the gifted asset. It is not possible to transfer partial or conditional ownership as HIBAH. The item must be totally owned by the donor and free from any obligation or conflicts. Delivery. The recipient must legally or physically receive the asset. For the HIBAH to be certified valid, ownership must be transferred. Voluntariness. The giving of the HIBAH must be voluntary and free from the threat, pressure, or force. The asset must be given as a gift with the donor's express purpose. Specify an existing asset. The current situation must be particular, obvious, and current at the moment of the HIBAH. HIBAH cannot be used to future or uncertain asset. No exchange of consideration. HIBAH must be a gift given without any expectation of payment, compensation, or return favor. Clear intention and valid purpose. The donor must have a sincere purpose and the HIBAH cannot be utilized illegally to avoid taxes, obligation, or faraid. Right to revoke or cancel. Traditional view. According to the conventional Islamic law, a HIBAH is final and unchanging once it is finished and property is given. The giver cannot take it back without the recipient approval. Conditions under which revocability may be allowed. However, there are certain conditions under which the donor may retain the right to revoke the HIBAH, depending on the school or thought. Conditional HIBAH. According to certain scholars, if the specific event does not take place, a gift that was given with broken condition may be cancelled. HIBAH to the donor own benefit. A gift may be withdrawn unless the giver gives up any right that benefit them, such as allowing use for a certain amount of time and intention of HIBAH. Shariah issue. Ensuring the HIBAH is genuinely a gift without expectation of any return or compensation. Contemporary revocability of HIBAH. A HIBAH is revocable before to ownership but final after receipt, based on Islamic jurisprudence. Unless there is strong reason, revocation is avoided. Conditions imposed on HIBAH. According to traditional Islamic law, a HIBAH should be unqualified. Adding limits may make it void. HIBAH as an estate planning tool. Shariah issue. Giving asset while still alive, or HIBAH, is a way of avoiding Islamic distribution regulation, which bring ethical and Shariah problem about ignoring the clearly required principle of just distribution. Documentation and legal enforcement. Shariah issue. In previous centuries, HIBAH depends on witness and verbal agreements. However, in contemporary times, official documentation is necessary for legal validation. HIBAH for minor or unborn beneficiary. Shariah issue. Researchers argue on whether HIBAH can be given to minor or unborn child, as well as how guardians should handle the gift. Hybrid transaction. Shariah issue. Some contemporary products, such as Islamic financing or takaful, incorporate HIBAH as part of the contract structure. Taxation and regulatory compliance. Shariah issue. While HIBAH is not taxed under Shariah, it may be under contemporary legal system which makes it difficult to adhere to both Sharia and state law. Hibah for charitable or philanthropic purposes. Sharia issue. Hibah for non-profit or waiver must meet certain requirements in order to ensure that the assets are used correctly.